Take our seats. I'm going to invite the next panel and on oversight and legal issues, and hopefully we'll stay a little bit more within the time so that we don't we're not too hung in time. The panel, Oversight and Legal Issues, will be moderated by Dr. Steven Zamora, and the participants, Ana Elena Fierro and Mara Hernandez. Mara? Okay, I don't see Mara Hernandez. She went backstage. Okay, she'll be here in a minute. And Alejandro Posadas. I'm inviting Mara. Okay, here you. Great. And Alejandro Posadas. Oh, there you are. That's it. Okay, we'll begin our panel. Stephen, all yours. Yeah.
Are we doing a videotape of this? Yes. And will it'll be on the website later? Mm-hmm. Okay, the title of this panel is Oversight and Legal Issues, and I will warn my colleagues on the panel that I follow the Benito Mussolini school of panel organization, which is we're going to stay within the time frame. I was so impressed with the first panel, but we're going to be even better than the first panel. And by the way, one of the things I love about the Baker Institute is that they do videotapes of these sessions. And so if you're bored at 11 o'clock some evening and you want to look at this again, you can do it. You can go on the internet and see. And that's why I took a shower and shaved this morning, because I knew that it was going to be. So tell people who are interested in these subjects, if they weren't able to join us today, that they can see these and other wonderful presentations at the Baker Institute on the website. Okay, so without further ado, let me introduce our three speakers. Ana Elena Fierro Ferrais is Dean of the Masters in Administration and Public Policy at CIDE, the very elite university in Mexico City. Mara Hernandez Estrada is Research Professor, School of Government and Public Transformation at TEC de Monterrey. And Alejandro Posadas is Research Professor, School of Government and Public Transportation, TEC de Monterrey. Recently, he's moving into another position. But we are going to begin with Ana Elena Fierro Ferrais, and her presentation, or her essay, is entitled Accountability, Transparency, and Responsibility in Mexico's Energy Reform. Ana Elena.
Thank you. Well, I want to first of all thank you, of course, the Baker Institute, Stephen, Tony, Lisa. Every time I've come here, there's been a very enlightening experience, and this is, of course, no exception. I have titled the words that I'm going to say today, Trust and the Mexican Energy Reform. Trust is an essential element for any legal system. Without trust in the law and the authorities, no public policy or reform can really succeed. In Mexico, there has been an increasing lack of trust in rules and the ability of institutions to apply them. In 2015, the Corruption Perception Index from Transparency International, Mexico ranked number 95 out of 167 countries. On a scale of 0 to 100 points, Mexico has only 35 points. The truth is that the Mexican system seems to rely more on personal relationships. Mi compadre y mi amigo are gonna grant me that contract for sure. Than the rule of law and fair competition. Thus, experts like Mario Amparo Casar have concluded that corruption in the Mexican system or the Mexican legal system is systemic. That means it's the rule. This is not a phenomenon exclusive of Mexico, of course, nor is it unsurmountable, but it requires a conjoined effort of government, legislator, and civil society to guarantee that the rule of law is in fact the rule and not the exception. Countries that today are considered some of the less corrupt in the world, like Sweden or Singapore or Hong Kong, underwent important anti-corruption reforms. In the case of Sweden and the Nordic countries was in the late 19th century, and Hong Kong and Singapore in the 1970s. These reforms guarantee that the rule of law is a rule that provides over personal relationships, so I'm confident it is not impossible. In March 2015, the Mexico Constitution was reformed to construct an anti-corruption national system, which main objective, as the Constitution establishes, is to create processes and agencies that efficiently prosecute corruption. But ironically, for the reform to really work, it requires that citizens and authorities regain the trust in the rule of law. For that to happen, it is not enough to prosecute bad civil servants. As the Swedish experience shows, it is necessary that the legal systems guarantee equal treatment to all, access to public information, and accountability of public offices as well. Only with all these elements, trust can be regained. Trust is especially important when you expect people to invest large amounts of money, as in the energy sector. Although all the statutes of the energy reform contain sanctions concerning transparency, accountability, and measures against corruption, they lack clarity and have important gaps. In the essay I wrote for this book, I outlined some of the most important and suggest some alternatives. Let me just tell you about some of them. For example, regarding transparency, the 10 statutes that conform the energy reform contain a chapter related to transparency obligations. Most of them have a long catalog of information that should be made public. The problem is that there's no uniformity on the way and periodicity of the information, nor when it should be published. This poses the risk that we can actually get drowned in an enormous flow of complicated, discontextualized, and sometimes outdated information. It would be desirable that the information published under the energy reforms meet international standards, such as the Extractive Industry Transparency Initiative or the Open Government Agreement, which Mexico is part of course. In this sense, it is necessary to develop a proactive transparency policy that understands public information is an essential asset for accurate decision-making and accountability. Therefore, the agencies involved in the energy sector should ensure that information is published following international practices that guarantee information is accessible, reliable, and usable by everybody. In order to ensure a fair competition, it must be said, as this morning was said, that the Ronda Una and the following auctions experience so far has been exemplary in the matter of access to public information. Hopefully, this might be an example that the other agencies involved can follow. As for accountability, in the statutes involving public resources management, like Ley Pemex, la Ley de Compañía Federal de Electricidad, el Fondo Mexicano del Petróleo y la Ley de Ingresos de Hidrocarburos, you can find rules regarding audits and other forms of accountability. Nevertheless, most of these procedures lack independence. For example, it is the board of directors of the public companies who appoint the external auditors themselves. The law is not clear on the purpose of the audits, not what are the consequences of bad results, thus rendering them almost useless. In this sense, what is desirable is that the Auditoría Superior de la Federación, which is the Mexican General Accounting Office, should be reinforced so it would be able to really audit the agencies involved in the energy reform, to establish earmarks on the subsequent budgets and punish, at least in the budget, bad results or unsatisfactory results. That would pose real incentives for the public companies and agencies to act in an efficient and productive way, as Article 25 of the Constitution mandates. The constitutional reform that created the national anti-corruption system has already reinforced the Auditoría Superior powers to audit and sanction. But in cases like the energy sector that are very specialized and technically complex, it is necessary to guarantee that the audit will have the expertise to effectively do so. As for fighting corruption, the energy reform has some very innovative elements, for the Mexican legal system at least. It expressly established that the situations that should be considered as possible conflict of interests, and the need for the directors and ministers to divulge them. The reform also contains rules for whistleblowing protection, as well as mandates for every agency involved to have ethic codes. Nevertheless, these sanctions that establish misconducts, procedures, and sanctions repeat many of the ambiguities and lack of due process that actually caused the anti-corruption reform. The statutes that will implement this constitutional reform are still pending. It is desirable that this legislation not only solve these problems of ambiguity or lack of due process, but also include the energy sector. That would imply maybe that those sections of the statutes that are put together as the energy reform should be repealed, so that all civil servants would have the same rules, or they have the same ethics codes under which to guide their conduct. As some of the speakers this morning have already stated, the energy reform implies a transformation of the Mexican government and its role in the development of the country comparable to NAFTA. It poses enormous challenges regarding the modernization of the industry, the quality of the public servants, and even the protection of the environment. But none of this is going to happen unless all the agents involved have confidence that the rules are clear and that it is a fair game. This is why transparency and accountability are so important, as well as an effective system to fight corruption. Last year's reform have made an important step towards guaranteeing the rule of law, but there is still a long way to go. Thank you.
Thank you very much. Excellent. Mara Hernandez Estrada is the co-author of an essay with José del Tronco Paganelli of Flaxo, Mexico, on energy reform and political representation, ? The importance of public negotiation and deliberation. Mara?
Thank you very much. Disclaimer also, I'm also not a lawyer. I'm also not a energy expert. But my colleague and I have been documenting processes of legal reform since 2009. With the overarching question of how does a Congress without a majority rule, like Mexico since 1997, produce agreements, political agreements that translate into new legislation. That has been the overarching question with which we have documented approximately 15 cases in this period of time. And the two main sub-questions is, on the one hand, what are the negotiation practices that political actors deploy to build cross-partisan agreements? Can they be considered effective negotiations in terms of regular negotiation theory, a standard contemporary theory of whether the pie is expanded, the value is created, and also who claims what part of the pie? And then the secondary question, because in political negotiations, that's not enough, right? Like who is taking what part of the pie? Is it a good pie or is it a bad pie? So negotiation theory doesn't really have a question for that. So we add another dimension, which is what kind of deliberative fora informed decision makers? Were they inclusive? Did participants engage in a reciprocal exchange of reasons in a public-spirited manner? Or was it just kind of a power struggle? So these two dimensions, just to illustrate, can produce a 2x2 matrix like the one I have here above. So we can actually have a very simple typology of reform processes. We can we can have no agreement, no deliberation. So the negotiation failed, and nobody really had a productive conversation, which is. We can also have negotiation without agreement. I mean, negotiation without deliberation. And a good example of this in Mexico is 2006 called Televisa law. Maybe some of you are familiar with it. It's famous because it was discussed in 7 minutes, discussed and approved in 7 minutes in Congress with the support of the 3 leading parties. So highly effective negotiation, no deliberation. And then deliberation without negotiation, which is also very typical in Mexico. You have these huge, very plural, very inclusive forums where everybody expresses their point of view, and then nothing happens, right? So, but there is also the possibility of having both. And we have worked on we have undertaken this research under the working hypothesis that a stable and democratic change occurs when processes have both effective negotiations and quality deliberations. And we do have, as an example, in Mexico, the iterative processes of transparency reforms since 2004, then in 2007, and recently in 2013, 2015, we have had iterative processes of transparency reforms that actually adhere to both effective standards of effective negotiations and quality deliberations. So it is possible, and that's kind of the main finding that we have had in our research, is that it is possible. It's not the rule, but it's possible. And what makes it possible? It's a combination of political practices that combine each other. So an example of policy practices that combine with each other are, for example, closed-door negotiations with the key stakeholders that are part of the coalition that's going to approve the reform, the more inclusive of key stakeholders, the more it can be an effective negotiation, but and also quality deliberation in that small door. But if you don't combine that with public forums where you of accountability and where you subject the agreements of these small group discussions to the scrutiny of public deliberations, then you don't have complementary practices leading to this upper right quadrant. So I have only 4 minutes left, so Laura. So we investigated the 2008 reform, and that was since there we had the clash of visions of the nationalist clan that was supporting strengthening the nationalist industry versus the more market-centered vision. And that example was surprisingly a fairly deliberative and consensual reform in on a taboo issue that was seen as a breakthrough given the fact that it was a taboo, but it was actually kind of a little bit of everything, right? A little more flexibility, a little more fiscal accountability for Pemex, and a little bit more also long-term planning, right? In contrast, the most recent energy reform is clearly a victory of market-center-oriented coalition. It is best characterized as a radical change in favor of opportunities for private investment and competition against, and it's against state monopolies. We can say, what can we say about the process that enabled this reform, and why might process matter? For most recent energy reform, for this most recent energy reform, we interviewed 20 representatives from key stakeholder groups, and we can say that the negotiation is an effective coalition of the PAN and the PRI, where industry and market-oriented experts were deeply involved in both negotiations and deliberations, high-quality deliberations within this coalition. The negotiation created much value for this coalition, balancing between state and private interests, and potentially also beneficial for consumers that might benefit from lower prices. And the pact for Mexico was also a key element in creating a momentum for this reform, and the incarceration of Elvester Gordillo that served to placate some believe the leaders of of the Pemex Union. The deliberation was in intense public forums with a wide variety of actors sympathetic to the reform. Deliberation mostly excluded nationalist views, environmentalist NGOs, human rights organizations, and community representatives. The result, again, then is a radical change that creates value by increasing opportunities for investment and checks and balances between industry and government, within industry and the regulatory government agencies, but the significant exclusion of the nationalist perspectives and therefore a lack of a vision for a nationally owned enterprise, Pemex, and most notably, as my colleague Isidro was arguing, and very partial inclusion of environmental perspective. It took a very different political process in the recently transition energy law, passed almost a year after the other package of reforms, to more or less include a stronger environmental perspective and very marginal inclusion of social and community perspective. So we have these very autonomous regulatory bodies for the industry, but we have a very politically subjected environmental protection. It's not even an environmental protection agency, it's a ministry, for example. That reflects just the strength of the checks and balances that were imposed in favor of the industry, but not in favor of environmental perspectives, and least to say community perspectives or human rights perspectives. I think those were definitely, there's very little teeth to that, and very weak, I would say, institutions. We can talk about this later.
Mara, I should say, by the way, that Ana Elena saved you some time, so you have a couple more. She would like to donate a couple minutes to you if you would care. You know, we asked them to study the question for a year, and then we give you 10 minutes to say what you found.
Thank you. Okay, so as going forward, I see two paths. Either we addressed, also just to say one more thing before. So the exclusion of the nationalist perspective, environmentalist perspective, more or less, and social community perspectives excluded, create a series of legitimate democratic deficits of legitimacy. And so there's two paths going forward. So we address those deficits through additional reforms and public policy. So for example, the newly approved energy transition is a way of partially addressing in a substantive way the deficits on the environmental issues. Doing that for the vision of Pemex or for the strengthening of community, the rights of communities and actual and just and fair conflict resolution processes with communities, and stronger checks and balances there in the community-company relationships. Or push implementation disregarding deficits and face the risk of increasing conflict and polarization. Thank you.
Alejandro Posadas is the co-author of the study with Regina Buono of the Baker Institute on looming conflicts, again question, energy reform priorities, and the human right of access to water in Mexico. Alejandro.
Thank you. Thank you, Steve. Thank you to the center and to the Baker Institute and to all the institutions that collaborated in this effort. Of course, I want to thank and recognize my co-author, Regina Buono. It was a great experience working together in this chapter. The errors in the presentation, of course, are all mine. Very briefly, the chapter addresses basically the potential conflict between energy exploration and production, especially in unconventional shale gas resources and water issues in Mexico. And we try to address it from two independent but interrelated issues. On one side, we have a potential of exploration and production in the northeast, especially in the northeast part of the country, that we have their resources that some of them are part of the same basin that we share with Texas on shale oil and shale gas, and the scarcity of water in that region when you need important water resources to explore and exploit these resources. And we put that in the context of the whole water regime and water challenges in Mexico. And then the other two related issues are more legal issues or potential conflictive legal issues. On one hand, there are some legal priorities defined for the energy reform. Basically, the energy sector is still a strategic sector as defined by the constitutional reform. And then exploration, uses of land for exploration and exploitation of oil and gas are defined of public order. And on the other side, we passed a constitutional reform establishing the right of access to water in Article 4 of the Constitution, and this in the context of larger human rights reform. Let me put that, take that last comment and put the paper in the context of the rule of law, and just add this. My own view is that there are, in addition to the rule of law being understood as a the importance of pre-established rules and everybody abiding by these pre-established rules and authorities able to enforce them. I think there are other three very important aspects to the rule of law today. One of them is that these rules must conform to a higher standard based on the respect and dignity of the human person, both in its individual and community or collective dimension. And that's what we call the fundamental rights or human rights. A second element is that there has to be not only procedural but substantive access to justice in a broader sense, where courts and other mechanisms to settle disputes, including governmental authorities, are able to address, balance, and resolve competing and complex needs, interests, and values of our current society. And third, probably most challenging, but I think is perhaps the key element to the rule of law, is the internalization or incorporation of the notion of rule of law in society, in individuals. So I will say that in this context of the conflict of water and energy, perhaps the 2011 human rights reform, in my opinion, is probably the most significant reform in Mexico in the last 2 decades. The Supreme Court has already established that the new standard of review, or the new standard of regularity, as they call it, for all acts of authority or all acts of government are the human rights, both the ones in the Mexican Constitution and the ones in international treaties to which Mexico is a party. And, and that's basically where the potential legal conflict could arise between two different constitutional mandates, one in the energy reform, although in a transitory article of the reform, giving rise to a lot of interpretative issues yet to be resolved by Mexican courts about whether the transitory articles in a constitutional reform are part of the Constitution or not, and how they should be construed. And of course, potential claims of access, human right access to water, and others. What we have seen so far is a Mexican judiciary that is becoming more and more enthusiastic about the application and interpretation of human rights, of balancing these competing interests. There is one already. There is one, at least to my knowledge, injunction issued by Mexican courts in a case regarding the energy reform, and the claim is there about vested rights of a mining company. But there are other examples of claims by indigenous communities, for example, in the south part of Mexico, regarding eolic projects that are still pending in courts. Just briefly, I would just like to end with just giving you a very brief picture of the complexity of the water issues in Mexico. Of course, probably I could define it by the word unequal or uneven or irregular. We have a country where we have abundant water in the south and a lot of scarcity in the north, but where the north and central part represents 85% of the gross domestic product of the country. We have an inequality regarding access to water, although the country has taken big steps to expand coverage of access to water to 90% of the country. Still, more than 10 million people do not have access to water, and that is basically rural and indigenous communities, making this a question of inequality or social inequality and legal inequality. But it also, it is considered that probably 35 million people in Mexico, although having access to water, they don't have access to water of enough quality and regular access to it. So there, the challenge is huge, and the legal regime to administer water is also complex, having the federal government controlling most of the sources of water because they are defined by the Constitution as national waters, but the local governments, municipalities, having been in charge of providing that access to water to people. Finally, part of the constitutional amendment to access of water established that the Congress had to pass a new, what we call general law on water to substitute our current federal law on waters, and that was 4 years ago, and Congress has not yet passed the law. But that, because there has been a very strong debate about what that law, how that law has to implement the human right of access to water. So I will leave my comments there. Thank you, Steve.
Excellent. So, I would prefer, I have a couple questions and observations, but I would prefer to ask your questions, or have you ask your questions, and I can add mine if we have time. So,
thank you, Steve. Thank you, Steve. My question is for Alejandro. I think that water, the reform in terms of water legislation is going to be crucial. And it was stopped because of electoral period, 2014. So where do you see this going? What would be an appropriate legislation with regards to water? What you told us it's a complicated situation, and what happens in Oaxaca with the eolic projects and the proposals to do the same in Tamaulipas, for example, with all the problems that, and in Coahuila as well, with all the problems of water. What would, how you see this legislation coming? When do you see this coming?
Well, I know that they are preparing already the new draft at the federal government, at the National Commission of Water. The legislation also didn't pass because of the strong opposition of environmental organizations and the experts. I think that I think they have realized that the water as designed was responding only to a very engineering approach to infrastructure and providing infrastructure of water like it has been done in Mexico for several years. And I think hopefully they will move the law and incorporate important aspects of the content of the human right, such as for example, the need to provide water to remote areas, to indigenous communities, to non-urban aspects. Sustainability issues are key. I think that the most serious problem of water in Mexico is sustainability. We have 50% of our water coming from overexploited underground sources of water. The other is standards. We don't have international standards of quality of water, reuse, or sanitation, and that has to be in the law. And perhaps another one that I can think of very quickly is preventing the use of transferring water from one remote basin to the other, which affects all of the basins. So I think those are some of the issues. Thank you.
I would just point out that this is an interesting look at Mexican law and Mexican constitutional law. Every Mexican has a right to water as of 2012? 2012. But in 1983, they had a right to decent housing. Is that a guarantee, or is it a right? Now, we might say in the United States, oh, well, our Constitution, we are law-abiding. But we have an equal protection clause. We are all entitled to equal protection of the law, and I don't think we all get it, but the Mexican Constitution is a fascinating and very rich document. I think you should go home and read it this evening.
It's long.
Well, read it this month.
There's another question over here.
I think you addressed a very important issue, that is water, and it just pervades through all different aspects, particularly energy sector, food, agriculture, and of course human consumption. Now, in terms of energy, you mentioned that predominantly the areas that are rich in shale gas and oil has a shortage of water, because you need water for fracturing or exploitation of the energy resources. At the same time, there is also a need to properly dispose that water. Once the gas or oil comes out, there is a lot of produced water, and that needs to be safely disposed, because that is polluted water. So has there been any thought in terms of that? Also, I think there is room for lessons from this country, because we also went through the same question, same dilemma when this whole thing started back in 2009-10, around that time frame. So lessons to be learned from the experience in this country. And in many places, we instituted strict regulations in terms of reuse of water. Whatever produced water comes out, you have to treat it adequately and reuse it, so there is less possibility of disposing it underground or into the streams. So has there been any thought on that?
Yes, thanks. We agree, and actually I didn't get to that part, but the part of our recommendations are Mexico doesn't have still standards for or regulations for recycling of water or reuse of water. And some of the recommendations in the paper is for the Mexican government to establish use of brackish water for those projects, and also regulations for disposal of the water once used. And technological advancements or incentives for technological advancements for the non-use of water for the exploitation of the resources. I will just add one more thing that I think it's important in this context, in this scenario. It has probably to do with the new law. Right now, the National Commission has to make the decisions on the use of water, and it's supported by basin councils with citizen participation. The problem under the current law is that once the National Commission has decided the use of the water, they can later change it. So one backdoor to these type of projects could be the Commission deciding to provide water for urban purposes, and a couple of years later say, oh no, I'm going to change it, and it's going to be for production of shale gas. And actually, we had a very important project. It was going to be the largest water aqueduct in Mexico. It's called Monterrey 6, bringing water from San Luis Potosí and Veracruz to the city of Monterrey. And it was stopped also because of protests, because the city of Monterrey actually has water secure for the next 15 years. It's one of the most efficient cities in Mexico in terms of use and conservation of water. And the experts thought that, and environmental groups thought that the real reason of transferring water from the south to Monterrey City was later to divert that water for those kinds of projects. Thanks for the question.
I have the microphone over here. In the meantime, Mara, a question as a political scientist, I'm kind of curious about your coalition building and the losers and the winners, the included and the excluded in that. As it was said in the earlier panel, there have not yet been any protests in the streets, and the people unhappy with the outcome have not yet acted out. Yeah. Under what circumstances do you see that they can coalesce in opposition, especially with an election coming up in 2018, and potentially derail some aspects of the energy reform or create some trouble? Under what conditions will these losers of the energy reform or the excluded of that may act up.
Yes. Okay. So the first thing probably to answer is that the reform did not face. Why did the reform not face huge social mobilizations, as in 2008 many expected would happen, right? And so we have like two hypotheses. One, and they're not mutually excluded. One is that the Pact for Mexico created a huge momentum for reform, and not just among the elite, but also the population at wide kind of was quite supportive of the pact within the first 2 years of the administration, the first year and all the way to until Ayotzinapa, I would say, and so there was this momentum. Also was kind of a license. You know, I might not be I might not agree with energy, with the privatization of Pemex, but it's okay that the reforms are taking place, kind of thing. So, and also kind of like we say in Mexico, Pedro y el Lobo, no? Always say that the opposition always say privatization is coming, privatization is coming, privatization is coming, and so really nobody ultimately believed it was really coming this time, right? So kind of that kind of situation, and very important, the Pact for Mexico also had the effect of dividing the left. So the moderate part of the PRD really was quite tolerant of the reform, even if it then did the consultation process to overturn it. It was quite tolerant. It was not really anti-systemic in its opposition to it. And on the other hand, Andrés Manuel and the other left parties were much more against it, but they weren't united. And so if you think of Mexico City being governed by Mancera, who's the mayor, he's not allied with Andrés Manuel in this process. So, but if Andrés Manuel as a mayor had actually led mobilizations, it would have been very different story, because the government in Mexico City, the left government has huge clientelistic networks that it could have mobilized, and they weren't actually mobilized. So I would say those two things: the momentum of the Pact for Mexico and the division of the left. Moving forward, I actually see the greatest threat for reform not more in conflict in the local communities, in the rural areas, and I see also a risk for violence there. So it's maybe not going to derail the reform, but it might create a very unfriendly environment for investments if we really don't create address those deficits of legitimacy and build proper conflict management institutions. I think that is the biggest risk. I don't see a huge mobilization to derail the constitutional reform as a mass mobilization issue. I really don't see it. Maybe it could happen if actually it is true the rumors that Pepe Toño, the new Pemex director, if he is actually going to shut down Pemex, as some rumors are, yes, that might be an occasion. But I don't think that is actually going to happen in the next few years. I don't think so. That would be maybe something that Mexicans might say. At the same time, I think, you know, we are so fed up of corruption, and Pemex is associated with corruption. So I'm not sure like Mexicans are really ready to wrap themselves in a flag again and defend, you know, what is seen also as a pretty corrupt institution. So I don't see that as a main risk. Again, I think it's in the rural areas.
Tony, yeah.
Oh, yes. Since we're in the area of legal issues, I was just wondering, in terms of human rights, what right do the Mexican citizens have to legal representation in terms of either human rights or workers' rights, and or what is the likelihood of there being class action type of suits in Mexico with regard to any of the issues that might come up?
Alejandro?
Well, if you mean the legal representation in terms of unionizing and that?
Litigation.
Yeah. Well, we now have class actions on certain issues available. Environmental issues is one. So that's one remedy. We have our amparo. It's our constitutional remedies, like the habeas corpus, but stronger and larger for any constitutional violation. Can also be now submitted collectively, so a community can file an amparo and not only an individual. Certain NGOs can file both collective actions and amparo remedy. So I want just to take this opportunity to say, as a lawyer, I think the Mexican system provides ample resources, legal resources. It's a very rich legal system. And I think that we are living a very interesting time because the human rights reform, I think it was not imposed from the top down to the bottom, but the other way around. It was very much a citizen's demand, very strong, and also it was pushed by the same judges. The federal judiciary started construing human rights in a much expanded way years before the Constitution was amended. So I think this creates a very interesting scenario, and we are seeing that, for example, there is this very significant decision by the Supreme Court, the Xochitepec case on water, access to water that we address in the paper, ordering a municipality to provide water to a community because of an issue of inequality. There was a poor community next to a very rich community. The rich community had water and the poor didn't. So I think that's the trend.
Ana Elena, would you like to comment as well?
I would. Well, of course, we have a constitutional right to an adequate defense, but sometimes that's only, as Stephen was saying, a written thing and not a reality. But at least about regarding the legal defense, we actually have public defenders even in administrative courts. So that's something really interesting. I mean, it's even been discussed if this is fair when a company is coming to the court and to have a public defender, but you could actually do that even if you're a company. So we do have that, and we also have public defenders in the federal courts for any kind of subject. And it's in the federal courts where you would promote an amparo, which is like it's a very expanded habeas corpus, actually, which will protect all the Constitution. As Alejandro was saying, which I completely agree, the judicial activism we have been seeing more on the Supreme Court, but more and more also in federal courts around the country, has really pushed towards this area. Maybe the big risk is having better lawyers. We have even started discussing the need, for example, to have clear rules on how to get, like you have, like the bar exams and things like that for our lawyers, because what we do have is sometimes defects on the adequacy or the preparation of the lawyers themselves.
Just to add one comment
yes.
there. Yes, I think that the background of the reform on human rights is a good thing in, because these blind spots of the energy reform are somehow balanced by the fact that we had this other reform on human rights, but at the same time it creates kind of a funnel, right? Because if everything is judicialized and it has to go all the way to the court where there's kind of sympathetic judges and you have, whatever amount of cases in water, in issues on energy, on mining, this is really going to be a complicated scenario. But at the same time, it is, I think, in terms of a good news in terms of maybe that the conflict is not maybe going to go in the violent, it reduces the risk, I think, of violent escalation, but at the same time it increases the risks of impasse, I would say.
Okay, I think, Tony, we have time for a couple more questions, I think.
Yeah? There's one back there. So it's up to you, Stephen, if you want.
No, you called it.
Then there's one back there. And then I'll give you the microphone, and then we'll come to Mary.
Yeah, a question was asked regarding how to process water coming out of shale. But my question was even more basic, because you made the statement that there is not enough water in the northern part where there is shale. So from your point of researching the water problem, do you think that there is any scope for development of shale gas at all in Mexico then, based on all the comments you made of the problems of water? If that is the case, will investors be interested even when this energy reform takes place?
That's a very good question. I know more about water than shale gas production, and I think that what I understand is that because of the market conditions, it's not very attractive right now. The interesting thing for me is that apparently what I have heard is that potential investors and engineers are not concerned about the water issue. And it's perhaps because they haven't thought very well about these potential legal issues. And because traditionally, the National Water Commission has resolved water issues for industrial and agricultural purposes, and they are trusting that they will in the same manner for the north part of the country, but I think that the scenario that we have been talking about other type of remedies. I forgot, for example, we have a new environmental damage law, so you can claim environmental damages in addition to civil law damages, and that's another tool that there is. So this creates a different scenario, I think, that we need to think about it carefully.
My question is for Ana Elena. As Stephen mentioned, Mexico has great laws, and we are known for the great laws we have. The problem is the enforcement of those laws. Typically at the federal level, it's easier, but when you get to the local level, let's say a municipio, is where things get really challenging with the power that municipal presidents have. Do you see the energy reform changing any of those dynamics that are already in place, or do you think that it will be a status quo as it has been over the past?
Well, if I have this, crystal ball, I could tell you something. But now, what I would have to say is that it is very difficult to break the circle of corruption. It is, but it is possible. And the way for it to be possible is actually to start trusting each other. And something that worries me a lot with all this, for example, what we're calling national laws, what we are actually doing is stop being a federation. I mean, it would be easier if we just cross out from our constitution the article that says that we are a federation and become a central state. That's what we are doing with all these general laws. And the reason we are enacting all these general laws is actually because we say we don't trust local governments. But what I would say is this, you know, these local governments or the mayors or the governors, I mean, they don't come from outer space. They are Mexicans, as the federal government is also. So I think what we need is really to start breaking this circle of corruption, and it starts by trusting people. So when you go out on the country, for example, with the transparency general law now, many of the local governments are saying, we are not able to implement this law because it's quite expensive to implement, for example, all the requirements, and it happens also with the energy reform, all the requirements of public information that should be in internet. We don't have internet in our municipality, for example, no? They can say that. So I think what we need to do is really start communicating with these local governments and finding out their needs, not only pointing them out as the most evil civil servants. Mm-hmm. And I think that will help in both senses. I mean, that will help in order for them, you know, having more legitimacy for the reform. Because as Mara was pointing out, we have actually been approached, for example, in CIDE by Pemex, asking us to train them on negotiation skills, because now it's very difficult to go on the local level. For example, like when a pipeline is going to go through certain communities, the community won't let the pipeline go in, and they need to negotiate them now, because beforehand what they would do, they would either they're paid, and now they don't have so much money to pay for that. And when you pay one group, now that is not a monolithic authoritarian regime, then another group comes up. So now what we're going to have to do is start first negotiating and then establishing clear rules and abide by them, because there's not enough money to pay off everybody.
This reminds me again that something that I said at the beginning this morning, which is law is not a science. Guess what? There is a huge cultural element to law. So you don't, after 70 years of authoritarian rule, and I love it, you know, transparency. Oh, great, now we're going to be transparent. Forget about it. Well, don't forget about it. I take it back. Don't forget about it. Keep working at it. Keep working at it. A good preparatory study was Octavio Paz's Labyrinth of Solitude. Mm-hmm. The Nobel Prize winner. Read that, and it says something about the cultural background of all of this. Mm-hmm. So, fascinating discussion. Do we have time, Tony, for one more question? Very quickly.
I read your paper with great interest, because I was requested a paper on transparency, which is a subject I know nothing about. So I learned a great deal from you, and I realized in your paper that you concentrate a great deal on the transparency obligations of the Mexican government before its constituency. Mm-hmm. However, an interesting phenomenon is going on right now in Mexico, which is Mexico's insertion into the extractive industry transparency initiative, which goes beyond the governments, and which entails the participation of the oil companies, of the NGOs, of the civil society represented by NGOs, by the government, and also all sorts of stakeholders. And this is a very complex exercise, because the reason why Mexico hasn't entered into the initiative is because of the lack of consensus of these groups. But I do think that the transparency initiative has to go beyond the government, precisely because the government doesn't have a very strong incentive to be transparent. We see it now with the case of Lozoya. 2 days ago, Emilio Lozoya, the CEO of Pemex, resigned, and we don't have clear reasons about why he resigned. And also, I'd like to see what's going to happen after his resignation. Because yes, he resigned. We don't know the reasons why he resigned. And I would like to see a very clear analysis of his performance during the past 3 years. why? What is the state of Pemex after 3 years of an administration of a man who clearly was forced to resign 2 days ago? So I am hoping this initiative promoted by the Mexican government, civil society, and the companies will force not only resignations, but clear accountability about the performance of the CEOs of Pemex, CFE, and all the companies involved in Mexico. And I'd like to hear your comments on that.
Yeah, certainly one of the biggest challenges, and something that for the Mexican government is very difficult still to grasp, is that when you say you're transparent and that you have an open access to public information, that doesn't mean only for Mexicans. That means that it's global and that anyone can ask. Even when there are still some states that when you ask, you know, like for some information, that you make a request for information, they will ask you your address because they think that if you're not from that locality, you shouldn't ask. Of course, the national INAI will trump that decision. But the first challenge is to realize that when you sign the Open Government Agreement, for example, anyone in Sweden, in China, or wherever can ask the government and request information for the government. So I think that's something that we need to address very, very strongly. And as for accountability, I think really what's really pushing that is, like you said, the NGOs. In many senses, like for example, this initiative for administrative responsibility law that it's being right now pushed by the NGOs, mainly like SIDAC, IMCO. I think that's what's really going to push the government to start being more accountable. In the specific case of the energy reform, this is very difficult because if you read the law, and here I have to say that because we start writing these essays almost a year and a half ago, it was still not implemented. So it's really like an analysis of what the norms specifically say. We still have very big challenges on how is this going to be implemented. But something that worries me a lot is that, for example, the CEOs of the companies like Pemex and CFE are not, it says they are not responsible under the civil servants anti-corruption laws. So this is, I mean, this is ridiculous because what they say is no, because this is a company, and companies only answer, or the boards only answer to their stakeholders, but here it's all Mexico. So what you are really doing is having no accountability of the board of directors mostly. That I hope that with the anti-corruption laws coming up, these are the things that will be recanted.
Well, thank you very much. Thank you to the panel. Excellent discussion. If you think the discussion was good, wait till you read the book. Thank you.
Thank you. Thank you, Stephen.